Hello and welcome. Today we're going to see about arrest. Arrest can be broadly classified into two types. One, arrest by warrant. Two, arrest without warrant. Even within the branch of arrest without warrant, there is a wide spectrum. There are various provisions through which an arrest can be made. But the subject of our video is going to be confined to arrest through section 41 of CrPC, subsection 1, subclause B. Arrest Arrest is a word which can send a shiver down our spine. It takes away something which we consider inalienable to us, our freedom, a right which is fundamental facet of liberty, a right which is essential to enjoy other right. Depriving this right, we will concomitantly lose other rights as well. An ordinary man would consider this right inseparable to him. But the same ordinary man would expect the state to have an effective criminal system, a system where offenders are brought to book in no time. Uh, if not complete annihilation, curbing of crimes very effectively. That's a very fair and reasonable expectation. But practically, how difficult it is to maintain both the things. To an extent, these two things, an absolute personal liberty, of course, within the bounds of law, and an effective criminal system, to an extent, are incompatible with each other. For one to be effective, encroachment has to be made to the other, and vice versa. So, what legislation can do? Legislation has been confronted with this predicament. But two contending concepts, which both are essential: personal liberty, effective criminal system. How these two contending concepts are going to be reconciled with. How that balance is stuck. Liberty is important, so is effective criminal system. And we are going to see about that. Okay, now let's see the section 41. The subject of this video is going to be confined to section 41, subsection 1, subclause B. And there was a significant amendment made in the year 2009. And let's see how the law stood before the amendment and what was the amendment and how the law changed, what impact the amendment had in the law. And it wouldn't be much off the mark to say that if a law is amended, then the pre-amended law is either ineffective or not sufficiently effective. Otherwise, it wouldn't have warranted the amendment. So, how the law stood then, and what was the problem with the law then? First, it said a police may arrest a person who has been concerned in a cognizable offense. Then the replication of what the law is now: reasonable complaint, credible information, reasonable suspicion. The word concern is too vague, particularly to use in a section like this, which confers a power upon the police to make an arrest without a warrant, a section which is too important to be kept vague. The vagueness of the word gives a wide discretion to the police. It doesn't give, but it leaves out a ground where the police can arrogate to themselves and a wide discretion and wide latitude to make an arrest. What are the reasons that an arrest, for what reasons an arrest can be made? It wasn't explained then. So the police took to themselves whatever the reason they find it convenient, and they made an arrest. Earlier, apart from the malified intention with oblique motives, which we are not going to talk about, or which is quite obvious, there were few reasons which may appear bona fide, may not be completely lawful, but it's understandable. Some of the reason is that the police wants to make arrest to give a sense of reassurance to the terror-stricken victim, so that the victim can at least have a satisfaction, a primary satisfaction that the investigation is going in the right direction, or to give a sense of reassurance or calm down the public who are clamoring for justice. There are few crimes where their agitation in the public will be very high, particular part of the particular section of the public, and even in general there will be a smoldering anger, and to calm them, arrest has to be made. Although whether it's lawful or not, that makes sense. And in some cases, they even made an arrest for the safety of the accused, to save him from the wrath of public anger. And these were the conditions, bona fide condition which were given in the law report itself, 177th law report, based on whose amendment, whose recommendation amendments were made. So what happened is that an amendment were made, then the amendment didn't take away the power of the police, but it has clearly delineated the boundaries. It has qualified the power of police. Instead of seemingly in wider discretion, they have laid down the condition that needs to be satisfied in order to make an arrest. The first thing is that it said a person can be arrested, a police may arrest a person against whom a reasonable complaint exists, a reasonable suspicion exists, credible information exists, and then the police should have a reason to believe that he has committed the crime. The first thing is, and there are other 5 conditions as well, which I will come in the due course of this video. The word reasonable, credible, or really, gives appearance that it adds a certain level of checks upon the police. But those are the words which are very subjective in nature. Now, who decides what is reasonable? Who decides what is credible? And the police may say that, I have reason to believe. The law just says that I need to have a reason to believe. Law doesn't say that I need to explain to someone that I have reason to believe. So police may say that I have a reason. I don't need to I don't need to explain to anyone. And if it left as it is, then it will just be an enhanced tokenism and actually serve no purpose at all. A complaint may surreptitiously collude with the police and use a power to arrest as a bargaining power, or a leverage against someone to get what they want, or to seek revenge. So unless the words such as reasonable, credible, or phrase reason to believe are defined within the law, then it actually serves no purpose at all. But the problem is that these words can never be defined. There can't be a single definition which can encompass all the possible scenarios that police may encounter. Facts of case A will be different from the facts of case B. So what is reasonable in case A will have no application on what is reasonable in case B. So how this issue is going to be addressed? First of all, the word reasonable, or the phrase reason to believe is a stronger phrase than reason to suspect. So the police should have some credible, or the level of satisfaction should be higher for the phrase reason to believe. But again, it goes back to the problem, goes back to the old issue, which is that who's going to decide this. This is where the legislation faces a paradoxical predicament here. On one hand, the legislation recognizes that this person, a policeman, has the potential to abuse his power, and from the news reports or statistics, or even the concerns expressed by the the honorable apex court quite often, can attest to the fact that they have indeed abused their power very often. But on the other hand, the law understands that he is the only person who can exercise the discretion truthfully, who has the acumen to make that decision, who has the skill and ability and experience to exercise that discretion in order to curb a crime or to successfully conduct an investigation. And this is the predicament that the law faces. One, he has an high potential to abuse that power, but at the same time, he is the only one who can exercise that profitably. So he has to be conferred that power. There is no other option, but we have to take the risk that he will abuse that power. Law can't have a blind faith, hoping that we will exercise that power in a bona fide manner. But if he doesn't start abusing it, we can't just sit and resign to the consequence. So what can law do? What's the best option that we have? How to ensure, how to check that he exercises that power, that extraordinary power, bona fide manner. So this is where law creates a checks and balance. The legislation creates a checks and balance. Boundaries clearly drawn. Police has enough power to operate within that boundary. But if that boundary is transgressed, then there will be a check and balance which will ensure that it doesn't happen. Or if it does happen, make sure that they go back into that. So this is where the magistrate comes into play, the judicial authority. First, we must understand that the power to arrest is necessary. It is very essential in order to have an effective investigation. But that existence of power is one thing, but exercise of that power is a different thing. The police needs to exercise the power very judiciously. They need to exercise the power after applying their mind. They need to exercise the power keeping in the view of the rights of the person arrested. And they need to exercise the power only when, as and when it is needed. They can't arbitrarily exercise the power based on their whims and conjecture. But how to make sure that it does it? He will say that I have done it, but how to make sure that he does it in that way? A judicial authority is put in place there. Arrest can be made without anyone's permission, without judiciary permission, but within 24 hours, he has to produce the arrested person to the magistrate, along with the report stating how he came to the conclusion that he has that this person should be arrested. How he came to that conclusion. Then the magistrate has to apply his own mind and record his satisfaction before granting a remand. And for this particular subclause that we are discussing now, they have given only 5 reasons where arrest can be made. 1, his arrest is essential for the investigation. In other words, it does not, it doesn't cooperate with the investigation. Number 2, he's a flight risk. If he's not arrested, then his presence in court cannot be ensured. Number 3, he need to be prevented lest he continues to commit the crime. If he is not arrested, then he will keep committing the offences. Then he has if he is not arrested, then he may tamper with evidence or destroy the evidence, or he will induce witnesses of people who are who are acquainted with the facts, and he will induce them or threaten them. And these are the only 5 conditions for which an arrest can be made under this subclause. And one more information: a law report made another condition. Almost all the recommendation of the law report were adopted, but only one condition didn't make out with the final amendment. That is, arrest can be made to ensure the safety of the accused. That was a recommendation made by the law report along with the others, but the legislation didn't accept it. Rightfully so. So the magistrate has to check what are the facts, what are the materials, and how come the policeman, the officer made this arrest, what logic and how he came to that subjective satisfaction, and then whether any of these five conditions is fulfilled. One of these five is enough. He doesn't have to fulfill all the other five. One of these five condition is satisfactory. Then the magistrate has to apply his mind. Then only the magistrate can grant a remand. Magistrate plays a very crucial role. There's a sacred duty to ensure whether the arrest is made keeping in view, comporting with the law, comporting with our constitution value, whether the rights of the arrested person is violated or not. Magistrate is entrusted with this sacred duty to ensure that liberty of the person is not deprived without any reason, without a due process of law. Whether a due process of law is followed here or not is kept in the hand of magistrate to ensure that. Now, theoretically, it looks very well. A policeman has to apply his mind. A judicial authority has to check whether the policeman has applied his mind. But the issue is slightly more complicated than this. There is another side to this coin. What happens, whether wittingly or unwittingly, when the person's duty is to check, become overzealous, and started interfering with the investigation? The purpose of this section, the legislation considers that this section is necessary to have an effective effective criminal system. But a person who has to ensure that boundaries are not crossed started interfering when the police acts within the boundary. Then that will neuter the purpose of having this section at all. That will denude the power of the police, and it will lead to an ineffective criminal system. When a criminal system is not effective, then people's faith in the rule of law will get atrophied. It will get dwindled, and they will be vexed. People will get vexed, and perhaps may tempted to take law into their own hands. And eventually, that will end up having a catastrophic effect on the country. So, where the boundaries is drawn? Here, we must understand that as long as police acts within their rights, judiciary can never interfere. Supreme Court has said in a plethora of cases. The power to arrest is necessary, and the police, with their subjective satisfaction, provided it comports with the conditions of the law, can arrest a person. And I will give off the cuff few examples where the court has interfered and the apex court came down heavily on the lower court. There was one case where the judiciary said, before arresting, you should give a notice to him. It's some particular specific case, not in general. The court said that can't be done. And there is other case quite recently, an High Court, under the power of under the inherent power under the 482, said the word no coercive action can be taken / no arrest can be made. That's an interim order. A court said that that can never be done at all. Police right to investigation is independent of judicial interference as long as they act within the law, and they have a statutory right and a statutory obligation to investigate, and court cannot interfere in it. In fact, Supreme Court came down heavily on them and peremptorily sent a circular to all the Honorable High Court Chief Justice to instruct the fellow brother judges not to issue such orders like no coercive action or no arrest can be made. Such order can never be issued at all. So the power of police is independent. The role of judiciary and the role of police are complementary to each other. They operate in different spheres. In areas where they overlap, it is clearly articulated in the code itself, in the law itself. Unless it is said in the law, they cannot interfere. Even under 482, the judiciary cannot, High Court cannot interfere with the investigation of the police. It's the statutory right and duty of the police to investigate. And the other thing is that I left out earlier. there was not no provision to how to ask a person to come and attend the investigation, whether he needs his interrogation is needed or not. I think the amendment was made in and a section added was 41A, where if presence is needed for interrogation, the police can ask him to come to the place that like police station or a place that police states, and the person is bound to come. He can't say I can't come. So when a police needs a person for interrogation, they can call him and interrogate him. So the police can't use this as an ostensible reason, an excuse to arrest a person that he is not cooperating with the that his presence is needed for the interrogation. His presence is needed, you call him. That's what section 41A. A notice can be issued to the accused to come to the station to take part in the interrogation, and police for cognizable offense, police has to issue such notice, and the accused has to come. He has no other option except if there is any protection subject to the he has to come, but the arrest subject to the condition laid by the court, if at all any condition laid out. So that's the section 41A. Now, theoretically, everything looks very wonderful. The law has been clearly defined. The power of police is well, the boundaries is or well democrated. Now, what happens in implementation? The success of law can only be measured with the effectiveness of its implementation. How effectively it is implemented. Unfortunately, even the Honorable Supreme Court has said that police are arresting without abiding by this law, without complying with this law. And unfortunately, very unfortunately, magistrates are granting them remand mechanically. The police just reproduce what is given in the section in their police diary, and the magistrate just gives them the remand, grant them the remand without applying his mind, without ensuring the provisions laid out in the conditions are satisfied or not. So this is the condition now. The present condition leaves a lot to be desired, but hopefully it will get better in the future.